Hey, Kentucky, I'm going to give you a little bedtime story. It's kind of a vlog for this book, How the West Was Lost. And it documents just early Kentucky. It was a poor man's country with Daniel Boone, and then it became aristocratic with Henry Clay and the court factions. So I'm just going to read 5 pages. This might take 30 minutes or so. So just, play this, lay back, and it's a little bedtime story. Chapter 4, The Rules of Law. As David Rice prophesied for half a century and more after their American colonization, Kentucky lands were the objects of speculation and litigation. As absentee and settler speculators enlarged their claims, lawsuits entangled almost every tract in central Kentucky. Already in 1786, a French traveler sadly determined that Kentuckians would hardly know how to buy a piece of land without involving themselves in a lawsuit, often ruinous, always long and wearing. After Kentucky gained statehood in 1792, the disastrous legacy of the Virginia land system confronted the new state's governing officials. As lawsuits proliferated, judges tried to sort conflicting claims and invent some rules to reduce the chaos. Legislators wrestled with the problems of widespread landlessness and universal uncertainty about titles. Upon these rulings, judicial and legislative rested the property of residents and non-residents. The rules of law cost Daniel Boone all the lands he thought he owned. From the time he signed on with the Transylvania Partners, Boone traveled with speculators. But while he served great speculators and tried to emulate their acquisitiveness, he never mastered the imitation. In the world of hunters, from which Boone hailed, good neighborship meant giving meat away to folks in need. Courage and generosity were the measures of manhood and the basis of local authority. In the world of great speculators, however, accumulation of land established noteworthiness. To maximize self-advantage, the worthiest land brokers bent rules. In Kentucky concluded a transplanted Pennsylvanian, speculators must deceive others or lose very considerably. Boone was ill-equipped for the cutthroat practices of notable speculators. He was out of place in the courthouses and legislative halls where successful engrossers won their most important victories. For Boone and other Kentuckians who lost their lands or never obtained any, the rule of law was synonymous with the misrule of lawyers. Pioneers and their descendants yearned for a less complicated and more democratic legal system, which they hoped would diminish the role of lawyers and assign a family-sized farm to all adult white men. To the dismay of those who hoped it would become the best poor man's country, the new state of Kentucky became a paradise for lawyers. It was this reputation that brought Henry Clay to Kentucky, first as a litigator and then as a legislator. Clay became prominent in the resolution of land matters. His developed into an effective voice for the preservation of an independent judiciary and the protection of gentry property. There's a little picture here. Probably can't read none of it, but it's fun to see pictures, right? Yet, despite evidence to the contrary, the rule of law was more than the self-interested jurisdiction of wealthy lawyers and their moneyed clientele in Kentucky and across the early republic. Democratic influences curbed the power of bar and bench. Responding to popular pressures, decisions of courthouse and statehouse ameliorated dissatisfaction with the distribution of land. That popular pressures did not bring a more radical redistribution exhibits the remarkable capacity of Republican government to preserve commodity while conserving property. Similarly, the quieting of conflicts over slavery depended on this kind of settlement. During the first decade of Kentucky statehood, as exasperation with the maldistribution of land peaked, agitation about slavery also crested, but opposition to slavery, like that to land distribution, did not in the end upend the rules of law or the security of private property. On January 31st, 1803, a fire consumed the office of the Fayette County Clerk. As an early resident of the area admitted, 'twas believed the office was set on fire to destroy land claims. Yet no one in the vicinity of the clerk's office fingered the arsonist. The flames, it seemed, served the interest of neighbors who hoped the destruction of old records would result in a straightforward and fair redistribution of land among occupants. Arson was an extreme remedy, but the uncertainty of land possession summoned drastic measures. Virginia's allocation of warrants prior to verifying location created chaos aplenty. Claims, observed Kentucky's first historian, were scattered as autumn distributes falling leaves. In one case, cited by Henry Clay, the same identical tract was shingled over by a dozen claims. Kentucky legislators exacerbated the confusion by continuing to grant lands haphazardly. In 1797, the Surveyor General of Kentucky reported to the legislature that while grants for approximately 24 million acres had been issued, the state contained only half that much acreage. Inequality of holdings compounded the problem. In 1800, the richest tenth of taxpayers owned nearly a third of Kentucky lands in private hands. A tenth of taxpayers owned a third of Kentucky lands. At the same time, a third of adult white males had held less than 200 acres, and more than half possessed no land at all. No owners, smallholders especially, felt their title safe. In the late 1790s, Boone joined the ranks of the dispossessed. From the state of Kentucky, he procured grants to thousands of acres in addition to those he had secured from Virginia, but he never managed to finish the acquisition process by gaining clear titles. Again and again, overlapping claimants contested Boone's claims, and ignorance of the intricate provisions of law inevitably deprived him of ownership. Boone's deficiencies as a locator and surveyor cost him dearly. As more and more of his locations were discovered to conflict with other claims, Boone became enmeshed in numerous lawsuits. At one session of the Bourbon County Court in May 1788, 3 different men sued Boone for breach of his promise and assumption. All the plaintiffs won judgments against him. Through the 1790s, Boone listened to litigants impugn his honesty and accuse him of performing chimney corner surveys, making up instead of measuring boundaries, making up. Outside of court, he received assassination threats. Boone blamed his misfortune on complicated laws and insidious lawyers. As damage awards piled up against him, he became a civic about the injustices done to him by judges and lawyers. Eventually, he stopped appealing adverse judgments. Frequently, he did not appear in court to defend himself. His surrender resembled the abdication of his brother and longtime hunting partner, Squire, who grew so tired of giving depositions and answering suits that he became principled against going into town on any business whatsoever. In the fall of 1798, when Daniel failed to respond to a plaintiff's complaint over 6,000 acres of lost land, the judge ordered the sheriff of Mason County, where Boone resided, to take the absent defendant into custody. But the sheriff could not find Daniel Boone, who decided to leave Kentucky forever. Tens of thousands of Kentuckians shared Boone's sense of futility. As the volume of litigation multiplied, despair of gaining justice within the legal system deepened. Exasperation with the slow, expensive, and complicated workings of the courts made litigation a Hobson's choice for many claimants. As one set of pioneer petitioners recounted, ignorance of the law threatened to complete our ruin. Yet to prosecute our claim, the last cow and horse must be sold to maintain the suit. To decline the contest, the land upon which we had hopes of supporting ourselves and families in peace during the remainder of our lives will be wrested from us. Venting frustrations, folk wisdom ridiculed lawyers and those who resorted to them. One joke told of a sick lawyer who made out a will in which he left everything to the people. Asked why, the lawyer replied, "From such I had it, and to such I give it again." Before you go to law, the controversy is whether the money is yours or another's, advised the Lexington Almanac. Once the suit begun, the contrivance is that it be neither yours nor the other's, but theirs who pretend to defend you both. Punchlines packed a walloping message. In lawsuits, only lawyers won, for their livelihoods depended upon the contentions, broils, and vices of our citizens. Thus, lawyers deliberately complicated proceedings to justify excessive fees. The custom of the country in giving one half in payment to lawyers to save the other is too large, resolved a meeting of Fayette County farmers in 1798. That meeting, along with many similar gatherings, called for a new constitution and a rewriting of the laws to make them understandable to simple farmers. Most in need of simplification were the land laws, a chaos of Gothic ignorance designed to slow the course of justice while enriching lawyers. As a group, the lawyers of Kentucky did not earn much respect for their educational accomplishments. Defenders of legal intricacy argued that the land laws required half a life well spent to master, but few lawyers studied so diligently. In the last years of the 18th century and the first decade of the 19th, admission to the Kentucky bar required no formal training. The schooling of most lawyers consisted of a year as a clerk in the office of a prominent attorney. Any more, claimed one member of the Kentucky bar, made the fledgling lawyer an overmatch for half-hoop practice. Micah Tall, who built a substantial practice, boasted that when he received his license, he had looked into, but had actually never read a law book. That hardly crippled Micah Tall, even though most of his fellow attorneys studied Hoyle more than they did Blackstone. The lawyers liked to drink and gamble did not injure their reputations. That lawyers liked to drink and gamble did not injure their reputations, for these pastimes were endemic among free white males. The aggressive culture of backcountry men celebrated the conviviality and competition of all kinds of gamesmanship. Boasting was an integral part of betting. The way to be popular in Kentucky, discerned the transplanted New Englander Amos Kendall, was to drink whiskey and talk loud with the fullest confidence. So not 30 minutes, 15 minutes, or 12 minutes. It's pretty good stuff. You know, essentially, Daniel Boone lost every bit that was given to him. The 1% owned a third of the lands. Most, over half of Kentuckians, didn't even own any land at all. Henry Clay was able to find a tract of land that had a dozen different claims. The lawyer jokes are, you know, they're funny but depressing. Instead of you winning or the opponent winning, the lawyers win. Neither one of you won. The lawyers took both your money. The lawyers got all the money. When Kentucky began, it began the state conventions. There was 10 state conventions before Kentucky actually became a state. And there was two main factions. And one faction was the poor squatters, the poor man Daniel Boone types who had taken over land, built a cabin, raising corn, versus the land speculators, versus the court party, the judges, the aristocracy, the lawyers. The court party today in Kentucky rules. The court party, a district judge, the lowest judge, there's circuit judges, family court judges, circuit court judges, appeal judges, but the district court judges, the very lowest ones, they make $120,000 every year, and they get a fat-ass retirement check after they've only served, you know, their 4-year term. So they run the shit, right? Attorney General looking like he's going to become the governor. And if you got that money, you know, a lot of these judges have nobody run against them once they've got into that position. The lawyers can only get into office when the Supreme Court, the Bar Association, allows the lawyers to join the lawyer club. If you're good enough to be, you know, past the bar, then you could be part of the lawyer club. And once you become a lawyer, then you could run for judges. The lost state of Franklin in Tennessee, they banned all doctors and all lawyers from representing government. In Kentucky, it's the exact opposite. Only lawyers can become judges and circuit court justices. Only lawyers. I would get better justice from a simple farmer, from a simple merchant, from a peasant, from a homeless person than what I would get from a fucking lion-ass, filthy fucking lawyer. And like what they said, what does a lawyer, in terms of GDP, people make fun of teachers because they don't create anything, they don't make anything, they don't make any GDP, so it doesn't add to the economy, at least the equation of the economy when they add it all up. But what does a lawyer produce? The lawyer produces nothing but conflict and contention. And as long as people think that you can find remedy in the law, then they are justified in their lawyer tricks and bullshit. So that's How the West Was Lost by Stephen Aron, The Transformation of Kentucky from Daniel Boone to Henry Clay, copyright 1996. Check it out, Kentucky. Learn something. This is your foundation. This is your origins. This is the foundation from which our Commonwealth began.